Good afternoon, everybody, and welcome to the 20-minute talk by Commercial Collection Agencies of America. For those that are just joining and we have never been on a 20-minute talk, welcome. For those who are returning, an equal welcome to you. My name is Annette Wagner, and as I always say, I have the pleasure of being the Executive Director of Commercial Collection Agencies of America. Today, we are so excited for this session because it's a little bit different than what we're used to. We have a awesome PowerPoint that our speaker is going to present. A little housekeeping that I'm going to do at the beginning of the session. Our marketing committee at CCA of A is doing a fantastic job. It's a reconstituted committee, and they are just going full throttle to get the marketing of the association up to where it should be. So if you are not connected with Commercial Collection Agencies of America on LinkedIn, please take out your phone and do so at this time. Equally, you can connect with me. I would say that 99% of what I post is for CCA of A, so feel free to connect with me and I will accept the invitation. We have non-members on this call as well, and I would like to welcome our non-members and always encourage you to ask about membership in the association. At this time, I'm going to turn it over to CCA of A President Alex Rosen. Alex, you have the pleasure of introducing today's speaker.
Thank you, Annette. I'm proud to introduce Brian Cloud, everyone. Brian is a founding member of Cloud and Willis, a full-service law practice founded in 2003. In addition to creditors' rights law, Brian also has distinguished himself in real estate and corporate law. He practices in state districts, circuit courts, and federal courts in Alabama, Georgia, and Tennessee. Prior to Cloud and Willis, Brian practiced with a large-scale Atlanta law firm for several years, and he received his undergraduate degree at Notre Dame and his JD and MBA at Samford University. So without further ado, Brian, take it away.
Yeah, appreciate it. Thanks. Thanks for allowing us to do this. I think it's great that you guys these 20-minute sessions I think are good for education. It also gives allows the attorneys in most cases to talk about different topics that we're dealing with. So I want to make this interactive. There'll be questions at the end, but if you have questions during this time, you can always just I guess raise your hand and Annette will stop me and call on them. But talking today about commercial collections in the Southeast. Now I'm actually from Connecticut originally. I think I escaped down to the warmer weather of the Southeast, but the Southeast, I think it's like I put in this slide. There's, as far as commercial collections, like very creditor friendly courts, hardly any red tape that you hear from some of these other states, and then there's a lot of good collection tools that we have. And like any presentation, I do represent a lot of you guys, but this presentation I'm just giving you a presentation, and I'm not giving you any legal advice here. So like I said earlier, like Alabama, Georgia, Tennessee, all are very creditor friendly jurisdictions. No real red tape. We don't really have any of these what I refer to crazy attorney generals that are going after going after creditors. And we don't even really have any. There's no really any separate state collection laws. Usually, you find that the debtors are pretty much willing to try to work out things if you can get them served and get their attention. I think it's the judges like cases get resolved. They like people to go talk. Like in Alabama, we have this system called ODR that actually it's only for small claims cases right now, but it actually allows the defending cases to make offers to the creditor via email, via the online system, and you can either accept, deny, reject, or make a counteroffer. It's just another way of just trying to work things out. Because a lot of times in collections, we can always go to court and bring the hammer, but a lot of times there's usually always a resolution that the parties can reach. And a lot of times, a lot of courts are going to a lot of mediation these days, especially in my states. The courts are the first step in like Fulton County, Georgia is always mediation. Once an answer is filed, they always send you to mediation. So but you also have debtors that are looking to work things out. They don't want to have to go to court. We're used to going to court. They want to work things out because they know in most cases they owe the money. There are cases where they don't owe it and it might be fraud or something like that. But for the most part, they want to settle things. Courts typically move fast. In Alabama, everything's e-filing. Tennessee is an exception. It's everything is basically except for two counties is right now is mail out. So that hurts with the workflow. I know a lot of you guys are asking for updates, and sometimes it's really hard. I put in there except for Shelby County because Shelby County, which is Memphis, you can mail something right now. You can talk to David Mellison about this. You can mail something right now, and they'll receive it. They'll file it in 6 months and backdate it. They're like 6 to 9 months behind right now. It's very hard to. You can call there. You don't really get a good answer. So it's that county and the fact that there are no e-filing can be pretty frustrating for us and for our clients because it's hard to get the answer from the courts. But for the most part, they move fast. And a lot of Georgia's e-filing, some of it's not. It depends on all the superior state courts are e-filing and the magistrate courts they're split between the two of them. It would be ideal if everybody would file Alabama because Alabama has the best e-filing system. I know there's some other ones out there, but everything has to be e-filed and everything moves. The cases move because that's what we're looking for. That's what our clients are looking for. And it just makes it easier that way. And then as far as, I put down strong post-judgment arsenal. You have the bank garnishments, you have the wage garnishments, you can attach. I'll get into a little bit, some of the stuff, a little more detail, but whenever you record a judgment attached to any real estate property they have in that county, so that's effective. Especially, we've seen this first quarter, a lot of people asking for payoffs so they can pay it off as part of selling the case. And you see a lot of in consumer stuff, which we also do. But in the commercial world, you see it because a lot of people are signing personal guarantees and they're getting judgment against them personally. And so it's a tool that, it's important to get a judgment, record it, and then there's different tools you can use in all three states to try to, they're pretty much the same as far as trying to collect. So that's a good question. So Alabama, it's important to know the rules. They're all the same pretty much. Alabama, they're all 6 year statute of limitations. You filed in Alabama's district and circuit court. Small claims is part of district court, and it depends on the dollar amount. Anything under 6 is small claims. Anything from 6 to 20 is district court, and anything over 10 is circuit court. So you can file anything from 10 to 20 in either district or circuit court. They require e-filing, and you have, again, like I said earlier, you have the garnishments, you have the lien. So it's important to know your statute of limitations. Of course, you don't even want to wait six years to file something, but that's how and a lot of times we'll file, and I'll get into a little bit later. We'll file it in circuit court if it's over 10 because if you file it in district court, it's de novo. If you get a judgment, it's de novo, which means you can appeal it and you just start the whole case over. You don't take the record from the previous case to circuit court. You just have to start over. Georgia, you have magistrate court, which is up to 15,000. Anything over that is either in state and superior. Some of the counties don't have a state court; they always have a superior court, and so that's all depending on the dollar amount. And like I said earlier, the magistrate court can vary between whether you have to mail it or where you can e-file it. And state and superior is pretty much all e-filing. So it's 15,000 for that. And then Tennessee, 6 years again. You have general sessions and circuit court. General sessions up to 25,000. So you find most of your cases in that. The good thing about general sessions is you can pick your trial date. So like when we file it, we'll set it out. The trial date we set out, 4 to 6 months, and then we will. If you don't have them served by that date, then you just do a reset letter and get it reset. And when you get it for Tennessee, when you go to court the first time, you're going there to either get a default or to work it out. And then if you can't work it out, then they'll reset it for a later date. So that's effective because you can, for attorneys, we can pick the date. We're not relying on the judge to pick the date for us. The problem is there's no e-filing for them right now. They say they're gonna have it in the next year or so, but for right now we're having to mail out and in Memphis, in Shelby County's case, just wait for them to file it before we can do anything with it. Moving on. Here I put about just different strategies. I think I mentioned a little bit earlier. You have magistrate, small claims district, and general sessions in the three different states. They're all based on the lower amounts. They're like the small claims. Usually it's not like people's court, but it's similar. Usually the service time is, in Alabama, it's gonna be 14 days, and the other two states are 30 days for them to file an answer, but usually a little more relaxed. The rules are a little more relaxed. Circuit court, you have circuit court in Alabama and circuit court in Tennessee, and then you have state and superior. They allow for motion practice. They allow for us to file for summary judgment, serve people with discovery. The smaller cases like the magistrate court is usually no summary judgment, no discovery. It's answers filed, and usually you have a trial within 2 months. And I gave that example earlier, like we file cases in Alabama that are over 10 in circuit court because we don't want to have to retry the case in circuit court if we filed in district court and they appeal it. So anything over 10, we've made a decision that we want to file it in circuit court. And there's just different strategies that attorneys come up with to figure out how to. I always talk about like how to get from A to B as fast as possible, because I think that's what we're trying to do. We're trying to get a judgment and then be able to try to collect on it or try to sell it in the meantime.
Brian,
Again,
can I interrupt?
things.
Can I interrupt for a second?
Yes.
We have a question. Do any of these states allow for Zoom or virtual appearances for out-of-state plaintiff creditors?
Okay, so we find a lot. During COVID, everybody was doing it, and so some of the judges that have kept doing it have allowed us to appear via Zoom. A lot of them are in Atlanta area, but a lot of them have gone back to the normal way. And I think some of the judges are like I was able to appear in Nashville via Zoom a couple weeks ago. Clients ask for it, and the problem with asking for it is you file a motion to appear via Zoom. The other side will probably object if they can, and the judge might agree with them or agree with us, but it shows that your client might not want to show up for the court, and so that's the reason why. But some of them are still doing Zoom. We can do a lot of default judgments and motion for summary judgment that way, but a lot of them have gone back to live court sessions.
Okay,
So,
thank you.
thank you. And then here to talk about like when you're trying to decide if you're going to file a suit, make sure we get the underlying contract, account statements. In my office, we have a checklist. I think I talked about it in Nashville when I spoke. Make sure we have the correct legal name, who the registered agent, and that's kind of stuff that clients or agencies, if they get that information, I always look at share that information with us so we're not having to reinvent the wheel, but make sure we have all the supporting documents. Sometimes we get files and we don't have like the term. We have the first page of terms and conditions, or we have the contract and it references terms and conditions. I think that kind of stuff is important that we receive it so that we can set up the case correctly, so we can set it up for success to get the result that the client's looking for. Because it's important to know what the interest rate is, and then whether you can allow for attorney fees. Because in most of the states, you can, unless there's a statutory reason, you can only get attorney fees if it's in the contract. So if the client doesn't provide us with the contract, it's hard for us to get the judge to award attorney fees. So it's just important that you guys provide, or the clients provide, everything to the attorney so we know the information from the beginning. And then here talks about a little bit of our strategy. A lot of each firm's gonna be a little bit different. A lot of us do the same stuff, but we like with demand letters, we found recently. I was talking with Annette before we started the session. We do a lot of ones via email, and we found, especially in the commercial cases, we found that a lot of them will respond pretty much, not we get people that respond immediately. They might say, "Oh, we're out of business," so that's you can give that information. You have that information and give it to your client, or they'll say, "Give me a call," or they'll prompt us. So we found that to be effective. We were talking about Net and I were talking about earlier about something we might eventually go to in probably the near future, sending text messages to the debtor or the defendant, just to send a letter or just to communicate with them. Because like I said at the beginning, like it's all about communicating with the other side to try to get the result that's good for your client. It's important, so if you can do it via text, email, phone, letter, a lot of times they don't, I guess they'll, probably a little more responsive with phone calls, but letters they usually ignore, except for they get an email. Like I said earlier, confirm who the entity status is, make sure they're not dissolved. If it's dissolved, we typically report that to the client. You can still sue them as a DBA, but it's probably, it's probably a good indication that the company might be out of business. But again, I said it earlier, we have a checklist I went over in Nashville about what we do to figure out if it's going to be suit worthy or not. And then, like I said, just a few minutes ago, if you provide the complete file, it helps us to figure out, who the debtor is. Because a lot of times, we don't know the debtor. The client knows the debtor the best, or they should, because they're the ones that sold them something, or they had that relationship with them. The agencies and the law firms, we don't really have that. We're just going over what's in the documentation or what's in the notes from our client. So it's good to, we always conduct skip tracing with either IDI or TransUnion, and try to get information on the defendant or the debtor. So again, we use a checklist, and if you provide that complete file, I think it's effective in us figuring out who we're dealing with, and knowing which way we should go, and whether we should recommend sue or we should try to settle, or and then also here's something that I think that some of my clients have started doing. Like might be good, a lot of times we settle these cases, and a lot of my clients, especially in the consumer world, we have blanket settlement authority at a certain percentage. I think it might be effective if the clients or agencies gave the firms settlement authority from the beginning, so we know if what we're, because a lot of times it's hard to get the person on the phone the second time or the third time. If you give them that information, not that we're going to go, if they tell us it's 50%, we're not going to go right to 50%, but at least we know, because we're always going to try to maximize what we can collect on the file. But it's, just giving the attorneys that information could be, I've found it to be effective in getting things collected, and getting cases, over with. So, one more question, and moving on. Here I put just the litigation process. Everybody knows this. I did put in here, I know we've talked about it at the conferences before. Make sure I mean, a lot of cases go in default judgment, and making sure we have the information. And it's important that we know what the interest rate, and also like and I know we've talked about this. I know some of the clients will send us the amount that we need to collect on includes their collection fees. I would always put your collection fees not in the amount that you place, because I think that if we send out a letter and then we get an affidavit later on that the principal amount was 5,000 and we had 6,500 because they include the collection fees, then I think that's, we need to know what the amount is. So I would always put the collection fees they're not attorney fees, and in my states they have to be awarded by the court. So the court will award collection fees, attorney fees, in the case, but I think that has to be, when we plead it, it has to be pled as attorney fees or collection fees separate from the principal. I think that's just a pointer to think about. And then going in, like I said at the beginning, going to post-judgment enforcement, we have in my 3 states, we have all the same ones that we have the bank garnishments, we have wage garnishments, we have liens, we have discovery. And it all depends. To me, we have different internal things that we do as far as, post-judgment discovery, we typically won't do it unless it's a higher amount, because it hasn't always been effective. Some of the courts, they require permission, and some of the courts don't let you do it. It's important to always have a lien filed because, like I gave this example here, if you have a business that's trying to get a line of credit, the lender might require them to pay it off. So it's important that we record it because it does attach to any real property they have in that county where the judgment is. And also, if they have property in other counties, we have to record it there as well if we can determine that. Bank garnishments are always a one-time hit, so they're not always, they can be effective, but they're not as effective as, in my opinion, as wage garnishments because they are if they have a dollar in today and you file a garnishment, they get served, you get $1, and then $1 million goes, and the next day you don't get the million. So it's a timing thing. So you might be able to figure out when they're to get the payoff or an amount, but a lot of times you're just filing and guessing because you don't know when it's going to be served on them. And then the wage garnishment is something that we use a lot of, especially when you're dealing with guarantees or dealing with the consumer world, because it's an ongoing garnishment that continues until it's paid off. So unless they leave the job, then it's continues on. And in Georgia, one thing that's different is you have to file where the garnishee resides. So you might file the case in Savannah, but then the employer is in Fulton County. You have to file the garnishment in that different county. So you don't have it in the same county where you filed the case. Questions? And then I'll just quickly over this. We don't have. I know Michigan has a tax garnishments, but we don't have that. But we have all the other things. I think it's and again, like I said at the beginning, the consumers or the debtors usually try to resolve things. A lot of times they know it's out there. They just they're not in a position to do it at that point. So we have the bank, the liens, the garnishments. And then you can also, one thing that we'll do like charging orders or we'll execute on receivables because, if they're in business, they're getting money in, and we use the charging orders that will make us have ownership in the LLC so we can determine what they're doing or have a percentage of the LLC. So we found that to be effective. They pretty much don't like the creditor getting involved with their business, but it's all about putting different pressure points on people to get them to, in our case, pay off a judgment or pay off an amount that's owed.
That might answer Larry's
That's quick.
question because Larry says, how does a wage garnishment work with a sole proprietor?
I mean, you would, well, it does, in that case, it probably does not work. You would have to file bank garnishment in that case because they're not, unless they're getting a W-2. I mean, I know in my case, I have a W-2 at the firm and it's not a sole proprietorship, but like a sole proprietorship, you could not, they're not actually getting employment. They're just taking what's left, I guess. So it wouldn't work in that case.
Can you file against the receivables though, like you were talking about?
You could file against receivables for for the company. I don't know. I haven't tried that before. The I guess you probably could because those are what's owed. You could also you also try to file an execution on their customer is probably what you would do because you would want to and then they would pay you instead of paying and the debtor's not going to like that because they don't like them, they don't want their customers to know that they're not paying their bills to one of their creditors. So
Jared says you
yeah,
probably need a UCC in most circumstances, no?
you could. I mean, the problem is the clients a lot of times aren't doing that. I mean, I guess it depends on the client, but you could. I mean, that would be effective if you can get a UCC. But sole proprietorship, I think you're probably dealing with the bank garnishments at that time, or you could. But again, if you do a sole proprietorship and they own property, you could lien their property and get the money that way. You always want, just like you always want to have a personal guarantor or sole proprietorship so you can get them at them personally, because there's a lot, if it's just the company, there's a lot of ways to evade creditors to not pay it. So If you can always get a guarantee or sole proprietorship, I think I think it's more advantageous to the creditor. So I think you couldn't do the wage garnishment for sole proprietorship, but I think there's a lot of other stuff you could use to collect. Any more questions?
I like your pro tip on there.
Right. I mean, a lot of it's just pivoting to other stuff to try to figure out what how to collect. There's so many different options. It's just a matter of, and each one's, I mean, there's gonna be a lot of similarities, but there's a lot, each one's gonna be a little bit different, or it could be a little bit different. Um, Problem is you don't know when their payment cycle is, or you could. Um, the client might know that better than the agency or the law firm. And then you have to also, when you file it, I mean, coordinate. I don't know if you could get the clerk to coordinate with you. I think it's going to be luck if you can get that, get it served at the right time. I guess you could use a process server and do it that way, which for all our server stuff, we use process servers. Any more questions for you?
I have two more questions that were texted me. If you set the trial out for 6 months that you were talking about before,
Mm.
and the debtor gets served like within 30 days, will the court move the date up, or is it a date that stays?
Well, first of all, that first trial date I guess if their answer is not due yet, then you would move it. If the answer is if it's past the 30 days where the answer, then you would show up that day, get the default, or they would show up and you would try to work it out. And then they would reset the trial if you can't get it worked out. Um, but if they had an answer due, I think the judge might say, well, the answer was just due a week ago. I'm gonna continue this for a month. So
The other
uh,
question that I was given, for a client that is hesitant to, and this might be on a consumer account, for a client that is hesitant to send a social security number, how can an agency allay the client's worries? Like we always hear attorney-client privilege. Is that extrapolated to civil matters as well, or is it just for criminal matters?
I mean, I don't think they would have. I mean, as far as sharing it with your office.
Right. Well, you know, obviously each agency has a data security policy, right? That's
Mm,
part of the certification requirements.
right.
But some of the clients are very hesitant to give a social security number, even with that data security policy in place. What can we say to those clients who have a lot of trepidation to forward that kind of information?
Well, I mean, I think they could redact I mean, they could send it secure in an FTP or some other way. I didn't know I was getting IT questions, and then they could redact the last everything but the last four of the Social Security. But like I could get your Social Security in 10 seconds. For firms or agencies, you can probably get their Social Security without even and confirm that the last four is correct without even them sharing it. So I mean, if they want if they have that concern, I would just redact it, share it, and then the firm or the agency could get that information
Could
without.
get the information, yeah.
I mean, if you're using we use IDI or TransUnion, you can back into the Social Security for people. So,
And do you need the social security number in order to file a consumer lawsuit?
yeah, I mean, it's a good idea too, because if not, and they're in bankruptcy or, in the military, you could have some issues.
Okay.
So, any other one?
And any other questions?
And then this talks about like preparing clients. And I know I know it's difficult. Guarantees, you want to make sure it's a separate document or it's a separate section. It can't be like, you don't want to have the guarantee in like, the 13th paragraph in the same font as everything else. Cause the judge probably won't deem that to be personal guarantee because you know, it wasn't, written correctly. Or it wasn't, you know, you couldn't deem it the person who signed it would not have thought that it was a personal guarantee. Um, as far as delinquencies, and my advice just, as far as when you talk to clients, or my advice is just stick with to a timeline, whatever your timeline is. Like if you're gonna turn over the agency after 6 months, and the agent's gonna turn off to the firm after a year, that's what you want to do. You just want to, have that timeline and whatever makes sense for your business. Um, the um, And then here I put down, just make sure that we get the documentation. Because if you don't have it, a lot of times, like last night, I had to reappear for a default judgment because my client couldn't locate a certain document that was needed. And it's just important to have it so that we can efficiently handle the cases. Because they're gonna, you know, like I put in here, like virtually all the judges are voted in, so they're always gonna take the side, or as much as they can, of the consumer because that's their constituent. Um,
Sure.
and then one thing, you know what you're dealing with if you're dealing with proprietorship or LLC. Like I said, we use a lot. We file a good amount of charging orders to try to get access to the LLC, because we can, have owners, not really ownership, but you can get access to all their information, where they bank, decisions, because we have a judgment and we're filing a charge in order to get into their company, I guess, in a way. And then I've talked about some of this as gone along. We work the phones early. We're trying to utilizing emails a lot, and we're thinking about using texting, but we get that a lot of the information from IDI and TLO, because it's a good way. We have that checklist that we go through. Make sure you One thing, we make sure you're renewing judgments. Tennessee, it's only good for 10 years, and then Alabama's 10 years, you renew it for another 10, and then Georgia's 7 years and 7 years. So if you don't renew it, then when person goes to sell property, they could sell it without having to deal with your judgment. We do a lot of consent judgments. I think it's a good way to do a win-win with the other side. It allows, a payment plan, because a lot of people don't have the ability, if they owe $50,000, don't have the ability to just write a check for, 40,000 to settle it. Some of them do. Some businesses do. But if you're dealing with an individual or a personal guarantee or a company that's struggling, it's a good way to get a judgment and to have already have the judgment in place and a payment plan where the money's coming into you. And then three of my states, they follow the Uniform Enforcement of Foreign Judgment Act. So it's a pretty easy process as far as if you have a judgment in Illinois, domesticating the judgment to Tennessee, you just need the exemplified copy of the judgment, and then you file it. And except for Tennessee, you just have to file it, and the clerk will mail it out, and it becomes a judgment in 30 days. In Tennessee, you actually have to serve them, which can be delayed. It's just not as quick as the Alabama and Georgia states. But different tools to move judgments from one state to another. And I know a lot of people will use the venue clause to file it in say Wisconsin, and then they'll domesticate it to another state. So that's something that we see a lot of. So. And then here are just some summaries. And I think Annette's going to post this so you guys can use this. Like I said at the beginning, a lot of these three states a lot of it's very similar as far as everything: the courts, the people, the rules, and we don't really have any real rules as far as consumers or creditor rights, just a normal court rules. But and we all have all the different garnishments. So here's just a summary, and then here are just some takeaways that I have, that it's, to me, it's all about strategy and trying to put your client in a position to collect the accounts as much as we can. There's always going to be uncollectible judgments or uncollectible lawsuits, but trying to get that information. Like we talked about at the conference, it's important to have share the information. In my office, we utilize a checklist to make sure that we're doing our due diligence ahead of time to figure out what who we're dealing with, from what the client shared with us, what we can locate in TLO or IDI, that allows us to, to effectively collect as much as we can. You're not going to be able to collect everything, but at least you know what you're getting into or you can when you get into the file. Because I've seen some clients will just send you, 3 pages and it's, not much there. It's important that we get more information so that we can, you know, intelligently try to figure out how to collect this, or, go right to court, or call, or who we're dealing with, and, who we need to sue, et cetera. So, and that's about it. Does anybody have any other questions?
I like the one about having the settlement authority already established. I
Hmm.
think that that expedites because you certainly don't want to go back and forth, and you've got the debtor ready to pay, and you don't want any time. You don't want them to spend that money on anything else. So um, I think that's a
Right.
great best practice, and that's
Yeah,
incumbent upon the agencies to talk to their salespeople, so their salespeople then talk to their clients.
Yeah, because a lot of the clients, I mean, we do it. We sent out, because it's tax time right now. We sent out a lot of settlement letters and, via email, and we actually saw a 70% open rate, which is good, but really good. But you know, what client's not going to say, "Oh, you settled for 80%?" They're all going to take that for the most part, um,
Sure.
unless it's a personal thing for them. But I think it's important because you're right. You don't get a lot of opportunities to get them on the phone, or get in front of them. And especially when you go into court, they need to make sure they have some type of settlement authority, because a lot of times these clients, aren't showing up for court. We're going to court and we're litigating based on you know, on the documents and such.
Any other
Brian,
questions?
yeah, I do. Brian, you had mentioned when we place files with you, it'd be helpful if we separated attorney's fees and collection costs from the principal balance owed.
Mhm.
How do you feel about accrued interest?
Well, when you do an affidavit, you just put the principal there, and then you whatever the interest start date is going to be, May 1st, and then you put the interest rate. I would do the principal,
Okay,
because you don't want to do you don't want to charge interest on interest. So I
gotcha.
think,
So what?
like, if the client or the agency would send the file like, this is the principal, this is the interest start date, this is the interest rate, then I mean, that would make it a lot more efficient for us to when we take the file.
Okay,
Um,
perfect.
but
Thank you.
I've seen ones where they've sent it all combined, and then when we're going to file suit, we figure out that's not the amount.
Yeah.
Um,
All right. Well, Brian, I knew this was going to be a successful TMT. Thank you very much. Another reminder for all those who are on the Zoom. CCA of A is having its semi-annual conference this year. It is in Austin, Texas, April 19th through the 22nd. So if you have not registered yet, please do so, because it's going to be an excellent conference. And again, connect with us via LinkedIn. And Brian, we are going to put your presentation in the library. If I put my email, if everybody doesn't want to, if you don't want to wait for that, it usually takes a couple days to get it up. Just send me an email at my email address. We are very grateful to you, Brian Cloud. This was an excellent presentation, and I love the takeaway. So thank you very much.
okay, thank you. Thanks for having me.
All right.